Have you ever wondered how successful architecture, engineering, and construction companies scale their business?
Or have you ever wanted guidance on how to get more growth, wealth, and freedom from your AEC company?
Well, then you're in luck. Hi, I'm Will Forat.
And I'm Justin Nagel, and we're your podcast hosts.
We interview successful AEC business leaders to learn how they use people, process, and technology to scale their businesses.
So sit back and get ready to learn from the industry's best. This is Building Scale.
Hey listeners, it's Will here. Our mission is to help the AEC industry protect itself by making technology easy. If you've ever listened to our show, then you know that the three pillars of scaling a business are people, process, and technology. So if you suspect technology is your weak link, then book a call with us to see where we can help maximize your company's IT and cybersecurity strategy. Just go to buildingscale.net/help.
Today's guest is Jeremy Baker, the founder of Baker Law Group. Jeremy is a Chicago-based construction attorney who founded Baker Law Group in 2019. Prior to starting his own firm, he was a partner and a member of the National Construction Law Practice for 13 years at Schiff Hardin LLP, a large firm with over 300 attorneys. Since 2015, Jeremy has served as a liaison to the American Institute of Architects Contracts Documents Committee and prepares the AIA's widely used contract forms. He has lectured at Harvard University Graduate School of Design and also speaks and writes for prominent industry groups like American Council of Engineering Companies, the Construction Specification Institute, the Illinois Institute of Continuing Legal Education, the American Bar Association, Forum on Construction Law, and the AIA, both national in Chicago. He has served as an adjunct professor at the law at the John Marshall Law School, where he taught construction law course. In 2020, he was inducted as a member of the prestigious Society of Illinois Construction Attorneys. Jeremy's practice involves project structuring across many project delivery methods, including designer-led design build, plus contract review and negotiations. Jeremy has prosecuted and defended lawsuits in over 30 states and federal courts, but he prefers to help his clients complete challenging projects by emphasizing dispute avoidance and early, cost-efficient resolution of claims. That was a lot of legal jargon that you made me say, Jeremy. You didn't make me say it, but I said it because it was the thing to do. With all that said, really welcome to the show, Jeremy. We're super happy to have you.
I'm so glad to be here, guys. Thanks so much.
It took me back to my days of working at a law firm and thinking, I'm like, oh yeah, these are so many sentences and so many words and so many things. And I was just like, oh boy, I feel like I've been transported back 7 years. So it was a nice trip down memory road for me.
I was thinking maybe I should switch up my billing model to be paid by the word listening to you talk.
Seriously. I think I just made 6 minutes there. That's got to be, I don't know what your billable is, but that's got to be good money. So with all this stuff said, obviously we're going to talk about the law side of construction, but tell us your origin story. Tell us how you got into, becoming an attorney, as well as how you decided construction was the place to be, and tell us about your firm.
Well, I'm a guy who was a lawyer before I realized I probably should have been an architect. And so as much as I'm interested in the law is sort of the way that I am allowed to enter the interesting meetings where people are talking about designing, constructing buildings. I'm not a real estate lawyer. I don't know anything about real estate law. I just help people build buildings. And, I help with everything from sort of designing the project delivery model, how the project is going to be set up, to negotiating a bunch of contracts. But my real passion, as I think you alluded to, is early cost-efficient dispute resolution. My mission, if I have one, is to keep my clients out of litigation.
Yeah, we're going to talk a bunch about that because, attorneys historically like litigation. That's where the money's at in many ways. Obviously, still in an ethical manner, but there's money to be had there, certainly. So let's just dive right into that. So you have this belief that you should not be litigating everything or trying to get into this dispute. You want to, prior to dispute problem solving. Tell us about that. Tell us why that's your vision, why that's your mission, and why that helps not only your clients, but the industry.
Well, business owners in this space, they want to design and they want to construct and they want to, add to their portfolio and make a nice fee and have win-win outcomes. And they don't want to spend a lot of time, fighting over stuff that, it is, if there's another way. And since I serve people in the design and construction industry, to the extent that's what they want, it's what I want as well. And design and construction disputes are different than a lot of other kind of disputes. There's certainly good reasons to litigate. And I have litigated continuously for the last 23 years, and I expect I will for the next 25 years. It's a tool in my bag, and, I use it, but, I try to use it tactically and only when absolutely necessary. And so if I can help my clients focus on what they want to focus on and take advantage of the ways that design and construction disputes are different than other kinds of disputes that might be better suited for resolution in a courtroom, that's going to be the way that I go.
Got it. So the start of all of this starts with contracts, right? Like that's, you got to get into a deal with somebody in some regard. You got to agree on some form of terms. So why would a construction company need a contract attorney? Like, what do they bring to the table that they can't just figure out by themselves?
Well, it actually starts one click before contract negotiation. It starts with picking the correct project delivery method. And this is something typically that the real estate developer or the project owner is going to do. They have to decide for themselves which of a half dozen, common forms of project delivery are they going to pick. For example, if you're a real estate developer, you have to make a decision about whether you're going to separately hire the architect in one contract and separately hire the contractor in a second contract, which is one delivery method that has its virtues. Or if you have other priorities as a real estate developer, you may say, I'm going to hire one party to do both the design and the construction work. And so first, we pick the right project delivery method, and then second, we negotiate the right kind of contracts. And the further down the chain you are contractually, if you're a subcontractor, for example, these questions about project delivery selection are made by other people. And so you're right in the sense that in many cases with them, it starts with contract negotiation. But, I think contracts they shouldn't be considered something that is, an annoyance and you sign it, you shove it in a drawer, you don't look at it again until there's a dispute. When people are negotiating contracts in the design and construction space, there's really an opportunity that can be missed for the parties to make sure they're really on the same page, to have a meeting of the mind about scope and price, and insurance and, a lot of things that if fleshed out properly, in the early stages, a lot of disputes that may otherwise arise can be nipped in the bud. So, I do think that the win-win outcomes, dispute avoidance, or if necessary, that early cost-efficient dispute resolution that I'm going for, it does start with contract negotiation when people don't miss the opportunity to have a thoughtful interaction with their counterparty to make sure that everybody understands what the expectations are, both on them and the other party.
So obviously attorney and a business owner want to shed risk to this. So you talked about win-win scenarios. And if we're talking not necessarily about the trade partner that's lower down the chain of contract, but when you're the top, the developer, the owner, wouldn't it make sense to try to shred as much risk as humanly possible? And that inherently puts risk on others, the win-win part is where for me, it's like, it always sounds great, but like, how is that executed properly?
It's a great question. And, of course, it's true that the higher up the contract chain you are, the more bargaining power you have. I like to joke that in design and construction contracts, we follow the golden rule. Whoever has the gold makes the rules, right? So the real estate developer at the top of the chain, has the ability to pick the project delivery method and set the project up the way they want. And then, the further down the chain you go, people have less and less bargaining power. They're more stuck with the agreements that have already been struck upstream. And so it is true that there is a risk shedding element that happens in all negotiations. It's a question of sort of the philosophy of how you consider risk. I mean, risk can be just pushed away and shed, downstream. That's one way to do it. But another school of thought is to allocate the risk to the parties that are best capable of bearing the risk. Because, if you do that, what you wind up having are, projects delivered on budget and on time, and if there are hiccups along the way, they get negotiated over. If you're only of the mindset that that this shit's going to roll downhill, I'm going to push it downhill, it's going to shed all the risk that I can. I'm not going to lie to you and say that there aren't times when I choose that as the most effective strategy for my real estate developer clients. But, given my choice, I do think that while, contracts should be owner-sided, as between the owner and the contractor, they shouldn't be commercially unreasonable. They should be a tad owner-sided, but they should focus less on shifting risk away as allocating it to the party that is best capable of not dropping the ball and, executing the task or the scope of work so that we don't have a dispute in the first place.
So tell us a little bit about, we'll call it the risk. You talk about risk allocation. Can you go a little bit more into that? And what does that really mean? And how is that risk allocation hedged or dealt with?
Well, there's so many different sorts of risks in design and construction projects, right? I mean, and you never know when you're negotiating a contract, whether it's going to be the project that has mechanics liens problems or the building that's going to catch fire, or heaven forbid somebody gets injured, or, there's Americans with Disabilities Act claim, or, thousands of other types of claims. And so a good suite of design and construction contracts is going to be able to efficiently manage all of those things. And so it's hard to answer simply the simple question you've asked me without, prefacing it by saying these are very deep waters that we're treading in. But at a high level, risks that can be insured over, insurable risks, they should be insured. And it isn't just a function of buying insurance policies. Insurance policies work hand in glove with contract terms. And so understanding how to make sure that your contracts don't destroy the insurance coverage that you're paying a premium for, so that insurable risks can stay insured. And, if there's a problem, there, is an insurance payor, if that's appropriate. And instead of having 3 years of litigation, you can have, 3 months of negotiation. When there's a payor, which could be an insurance party or some other party, that is something that tends to promote early cost-efficient dispute resolution. We could also talk about, the risks of just scoping different parties appropriately. So, if I was building a skyscraper that had, a glass curtain wall on the outside, I could shed risk down at the contractor, and I could say, you're going to hire the curtain wall design builder, Mr. Contractor, and all the risk there is on you. And it's not to say that when I'm representing, people building skyscrapers, I'm not thinking and acting along those lines. But what I'm equally interested in is, like, who is the person at the curtain wall design builder that is going to interface with the architect? And do they have people skills? Do they have communication skills? Are they going to be able, to communicate effectively with their architect, firm counterpart? Because the skin of the building's got to marry up with, the rest of the building. So I am as interested in, making sure risks are insured, and we've got good project delivery methods and smart contracts and all that stuff, is thinking about where are we likely to have problems, and, do we have the right kind of people in place with the right kind of processes in place with the right sort of communication skills that are going to get on the same page, so that we don't have to test the quality of the contracts because, two designers that didn't have the ability to communicate with each other are the people that are designing things that interface, with one another. I'll give one more example because I could go on for hours here. I mean, another risk is a payment risk. If you're a general contractor and you're signing a contract with an owner of property, you're going to do the work first and you're going to get paid second in most cases. So whether you like it or not, you're extending credit. And if you're not thinking of yourself as a credit manager, in other words, assessing the credit worthiness of the owner that you're being hired by, you might be doing yourself a disservice. If I'm a general contractor, I'm interested to know, is the party signing my contract a single purpose, LLC, an LLC that's been created just for the sake of this project that may not have substantial assets? Or am I signing a contract with, the mothership real estate developer entity that has tremendous assets that may impact how I feel as a general contractor, how long I'm willing to allow my accounts receivable to run out before I think about suspending work? And if I do sign a contract with a LLC that doesn't have substantial assets because it was created just for the purpose of this one project, if I'm a general contractor, I'm really interested to know whether they own the building or not. And I'm interested to think about my mechanics rights. So, whether it's scoping a job right, or keeping insurable risks insured, or, thinking about who you're contracting with and conceiving of yourself as a credit manager, if you're downstream of the owner, these are three examples of, hundreds of things that I like to think about.
So there's two sides of risk decision, right? There's a legality side of it, like, hey, like this is amount of risk. There's also a business side. Obviously, you own a firm, so like you have insight into both sides. How do you keep that separate when you're helping your clients, of saying like, yeah, there's risk here, like there's inherent risk here, but as a business, sometimes you got to take some risk on, and like you got to do things that become a little bit more risky. How do you make that balance?
That's a fantastic question. And, I'm an interesting case study because I left a comfortable partnership at a law firm with, hundreds of lawyers to strike out on my own 5 years ago. And so, when it comes to my tolerance for risk, I've got a great appetite for risk, but when it comes to protecting my clients, I've got no tolerance for risk. But to get to the question that you asked me, there's a difference between legal decisions and business decisions. And the lawyers who I hire to work for me and my firm that help me negotiate contracts, go through a lot of training with me to be able to distinguish between a legal risk and a business risk. I mean, there are certain contract terms and certain, things that I would get very animated about. Thinking that there's a right approach and a wrong approach. And those are legal type issues. And, ultimately everything's business risk on some level, right? Like my clients can choose to not care about the legal issues that I'm flagging for them as being very important. But there's a difference between those kind of risks and business decisions. And when we go through a contract for a client, we are flagging the business decisions for them as we are trying our best to negotiate the legal risks, bearing in mind how much bargaining power my client has relative to the counterparty. And so things like how long are you willing to go unpaid before you suspend your services? It's a perfect example of a business decision. I could care less what the answer is. It's for my client to decide. My job is to flag the issue and make sure that they've got their eyes open and that they can make, a knowledgeable decision. And as long as my clients are taking on risk with their eyes open, I'm a happy guy. I represent real estate developers, and project owners, but I also represent a lot of architects and engineers and contractors and subcontractors. And I see a lot of my clients taking on tremendous risk. I give you an example. I've got an architecture firm that is doing work outside the United States when their insurance policy won't provide them any coverage at all for projects outside the United States. And that issue was flagged for them because I asked the right questions of their insurance broker. And they, with their eyes open, said, you know what, this is a great project for our portfolio. There's a lot of trust. There's a good fee here. We're willing to take the risks. And so as long as I do my job and I flag the business decisions and I flag the legal risks and I make sure my clients are able to, make a knowing decision, then I feel like I'm doing my job.
That's a good example because you may be more willing to take a risk in this example of outside the states, even though your insurance doesn't cover you. If it's like, this is going to be an iconic building, like this is going to if you were building something in, say, Dubai or, architecting something in Dubai, you'd be like, this is going to be known around the world. And that will put our firm on the global map where which will then maybe we'll have to get insurance that's more globally based and we'll deal with that problem later. But right now, it just makes sense to get this deal done or get this particular project, completed.
Yeah, and that's why there's a real, people side of all this that has nothing to do with the words we put on the contracts, has nothing to do, with who's going to win or lose a claim. There's different sorts of people. I mean, some people are risk takers and they go to Vegas, they go right to the high stakes tables. And there's other people that don't like risk. And when they go to Vegas, they head straight for a show. And I have to understand what sort of a client I'm working with. Because my job is to tailor, the contract and to set up the project, to the extent that my client has the bargaining power. I mean, look, if I'm way downstream and I'm a subcontractor, I might have the right to complain about one clause. And if that's the way it is, then that's the way it is. I flag the risks for my clients and there's not a whole lot that I can do. The further up the chain I am, I have great ability to sort of like set the projects up the way that I want. And I have to assess how much my clients care about different things. And so when I take on a new client, the first contract I work on, the first project I work on, I'm really trying to get an understanding of not just, what are their operations like? Where do they make money? Where do they lose money? What's the relationship with their counterparty that they're negotiating with? Do they have a long relationship? Is it new? Is it a public project where, their lien rights are different than a private project? Who are we dealing with? But also, am I dealing with a risk taker or not? And if I'm not finding out all of those things about my clients, I can't tailor the, contracts I'm negotiating to be exactly what they're looking for. And that's, sort of what I'm trying to do here is it's, to offer sort of a bespoke approach to giving my clients exactly what they're looking for so that they can, meet their goals. And, look, I mean, there's different people have different goals. Some people, they don't want any risk. Other people are willing to take risks and make more money. I have to understand that in order for me to serve them as best I can.
Obviously, you need information to be able to, from your clients, to be able to essentially do better with the contracts. However, are there concepts or just pieces of contracts that people miss or that are very typical of being missed, and that's why they get themselves sort of in trouble in the legality side or stuff that's not thought about?
There really is. And I said earlier that I'm not a real estate lawyer. And, I mean no disrespect to my real estate lawyer friends because they have a whole skill set that I don't. But, a lot of real estate developers hire real estate lawyers who are already on the deal because they helped them acquire the property and to finance the deal. Those same real estate lawyers negotiate the construction contracts. When it's an entirely different discipline and it's the unknown unknowns, it's the blind spots that people have in the law when they wander a little bit out of the area where they really understand things. There's, maybe 75 to 100 construction lawyers in Chicago who really know what they're doing. And it's spotting the issue that doesn't leap out at you that is the real, skill here. So yes, I mean, to your question, on every project, when I get documents to look at, the first thing I say to my client is, I need to run through an issue spotting exercise. Like there is going to be a request for a proposal and a proposal and scope documents. And it's just send me a Dropbox full of all that stuff so I can look at it and I can say, this is interesting. On this project, there are 3 unique things that you don't see on every project. And my typical approach to drafting a contract needs to take into account these unique issues. And so the ability to spot the issue and then to understand how to deal with it, that is where the real, skill is. That's where the real art is. And so, there are dozens and dozens of skilled construction lawyers in Chicago who have this club in their bag, who are not going to be able to do the real estate lawyer thing. My very smart real estate lawyer friends and colleagues, like no disrespect to them, they do something different. But looking at the project, spotting the unique issues, and then knowing what to do about it is, the skill. It's sort of like the difference between a multiple choice test and an essay test. I never liked an essay test because I was always scared of the blank page, because then you got to figure out, what am I writing on it? But a multiple choice test is easy. You sort of, you pick A through E and you hope you're right. Drafting, design, and construction contracts is more of an essay type function where there's a blank page, and the things that need to be on that page are not going to get on that page unless you have this depth of understanding of the deep waters that the clients are swimming in, and the ability to spot the issues specific to the project, and then marry up, what kind of risk takers, what's their perspective on risk? How much relative bargaining power do they have? I can't send them a bill that's greater than the fee that they're gonna, get on the project. So, how much do they care? Is this just fix the top 3 problems, or is it make it good as possible kind of problem? Is it a legal issue? Is it a business issue? How do I spot it? It's an art and a science, and it's the thing that I really enjoy. I think I said at the beginning that I sort of became a lawyer before I realized I was probably put on earth to be an architect. I'm thrilled to be able to still be in the room with the architects and the contractors and, the interesting real estate developers. The law is like, my key to the door that allows me to enter the room, to be involved in all of the wonderful details of these projects.
Can you give an example, obviously, without, breaking the platinum rule or
client privilege?
The privilege, client privilege. Can you give an example for the people of what you're talking about?
Yeah, I can actually. I can give you an example from this morning. I was out to breakfast with 2 owners of a well-known general contractor here in Chicago, who I'm just starting to work with now. And I envision that, like as is the case with most of my clients, it'll be a 10 to 20 year relationship where I'll help them every 90 days when something pops up that they need help on. They showed me some contracts that were prepared by, their former counsel, who wasn't a construction attorney, he was a real estate lawyer. And I flipped on to page 2 and I was looking for something specific, to see on that particular contract form whether the other lawyer had the wherewithal to make a change. And sure enough, what I was hoping to not see in the document was right there on page 2. And there's 5 particular words that I have described as the 5 most dangerous words in design and construction contracts. In a video on my website, I was telling my clients, I'm like, you can go to my website and you can see a video where I explain what are the 5 most dangerous words in design and construction. And there they were right there on page 2 of the document. And I was able to explain to my clients that while I have a lot of ideas for how I might change, the way their contracting strategy, if I did nothing other than change these 5 words, I would be making a big positive impact for them. So, anybody who's interested in what those 5 words are can go to www.buildchicagolaw.com, my website, and check out that video. There's about 100 of them, 100 videos on the website.
Well, don't keep us in suspense here. Give us the 5 words. Maybe the explanation can be done on your website, but give us at least the 5 words.
5 words are relationship of trust and confidence, which are code words, not in every jurisdiction, not in every contract, but they're code word for fiduciary obligation, which is among the very highest obligations that you can have imposed upon you in the law. So somebody who is going to enter into a relationship of trust and confidence with another party is maybe biting off more risk than they might understand. It's not to say that it's not appropriate to have those words in the document. I think that in the generous introduction, that I got, that may have been written by me, there was a note that I'm a liaison to the AIA Contract Documents Committee, which is a fancy way of saying that the really smart people on the Contract Documents Committee that prepare the American Institute of Architects, the AIA standard form contracts, which are very widely used on United States construction projects. Those people take input from people like me when they're preparing their new forms. So I happen to think quite a lot of AIA contract documents, and there's a reason why those words appear in not just the AIA contract documents, but a wide variety of other contract documents, because there are certain kinds of relationships between owners and contractors where it's appropriate to impose that high level of obligation on. So I'm not saying it should always be struck. As a matter of fact, I'm saying the opposite. I'm saying that there are times when I would object loudly to those words being struck. The point, though, is that I would bet 1 in 1,000 people that sign contracts that contain those 5 words have any idea what they're getting into. And that's the problem, right? Because business people who need to court new work and they need to sell and they need to enter into contracts, it's not an academic exercise. We're not trying to get an A on our paper. There's no such thing as a perfect contract. I've never drafted one, and I've never seen, what there are a bunch of compromises made based on people's risk tolerance, where the business people, hopefully, if things are working right, have their eyes opened up to the risk that they're taking on. And in the case of my breakfast this morning, my contractor friends had no idea the risk that they've been taking on. That's the problem. I don't have a problem with them taking on the risk. I have a problem with the fact that they took it on without realizing they were taking it on.
So there's obviously a bunch of benefits using a niched attorney. So, obviously construction, right? Hey, not a real estate attorney, construction, they're very different. What are other benefits? Obviously, the legality, these little nuances that when you look at a contract that are, these are pieces. What are other benefits of that? At Spot, we same thing, right? When you look at the AEC industry, that's who we focus on, and there's tons of value that comes with that. What other values come from using an attorney that is in a specific space?
Well, I can really only speak to the wonderful relationships that I enjoy with the smart construction lawyers in Chicago, and there's fewer than people would think. But we do quite a lot of business with one another. We're adverse to each other in litigation, arbitration, mediation, but sometimes we're co-counsel in litigation, arbitration, mediation, and sometimes we're negotiating contracts with each other when my clients got the gold, so they make the rules, and then other times we're negotiating contracts where their clients got the gold and they make the rules. And so there's a zone of commercial reasons, and smart design and construction lawyers understand from, walking a mile in the shoes of lots of different parties, how do you kind of stay within the bounds of commercial reasonableness? And so I don't ask people for things that would make them, go crazy unless there's a good reason for it. And generally when I work with these, experienced design and construction lawyers, here in Chicago, there's a wonderful bar here in Chicago, but there's a wonderful bar of national design and construction lawyers in all 50 states. When I work with them, they don't push me beyond, lines that I wouldn't feel comfortable allowing my clients to cross, and I don't push their clients beyond those lines. And when we get into disputes, because we know that we're likely to see each other again, there's a, level of collegiality and professional courtesy that's enjoyable, but it kind of gets to this idea of really cost-efficient dispute resolution, because unlike other areas of law, there are a lot of very specific doctrines that apply to design and construction law that most lawyers don't know about, that have a lot to say about the way that a dispute is going to be resolved. I'll give you an example. If if you have a personal injury case, which is something that I don't handle, the injured party might think that they're owed 50 million, and the defendant might think that the liability is 50,000. If that's the case, you go to trial, right? And that's a good example of where, you should use the court system to resolve the dispute because, there's more room to debate that. But in design and construction law, there are very well-established doctrines that people use to measure their damages, right? And so when I sit down in a negotiation, and there's a dispute with an experienced design and construction lawyer, I can say, hey, look, this doctrine applies and that doctrine applies. And that means that, like, on the damages side of this claim, we can fast forward the tape all the way to the end of the litigation. And we can know with a high degree of certainty that your best case outcome is probably this number, give or take 10%. It's not like we're going to be, off by, factors of, many multiples. And to the extent that they can understand that and I can understand that, we've already solved 50% of the puzzle, right? Because in any dispute, it really has two elements. I mean, this is a big oversimplification, but there's the question of, did somebody do something wrong, which is like the liability or entitlement part. And then the other half of it is how do you measure the damages, right? So if I crash through a red light and I don't get into a car accident, I did something wrong, and so the sort of liability entitlement side, yes, I was negligent, but there's no damages because I didn't crash, right? And so in every claim, there's the liability aspect and there's the damages aspect. When I work with an experienced design or construction lawyer in a dispute, we can fast forward the tape to the end. We can have a very good understanding of how the dispute is likely to look after a couple of years of litigation. And that really helps us cut the ring. It helps us think about, why would we spend a lot of our clients' time and money to get to an outcome a couple of years from now that we can predict with a high degree of accuracy right now? That's not something that I enjoy when I'm dealing with like a general litigator that handles any kind of claim. Because when I'm telling them that this is the way it's likely to be, they think I'm just advocating and they're inclined to just say something that is the exact opposite. So, I work with all kinds of lawyers, but I certainly enjoy my relationships with the design and construction lawyers, and certainly those at the Chicago Design and Construction Bar in particular.
So that does bring up so when you're dealing with these smart lawyers that are in that niche, great. But when you're dealing with a general litigator, say that, in a nice way, they may not be as keen on like, let's resolve this, earlier. Like for them, it might be, no, you're wrong. We're going to court. Like, how do you deal with that? Obviously, as an advocate for, making these, resolving these issues before you're, 3 years down the road and hundreds of $1,000s in legal fees. Like, how do you convince them? Like, no, like, stop, don't think this way. Let's think of this a different way, because litigators don't like to be wrong, I've learned. And I don't know if that also falls to you, Jeremy.
You're right. And I mean, I deal with every stripe of lawyer, and, you have to have a lot of different clubs in your bag to deal with different situations. And, I am a litigator and I don't like to lose. And like, if I do everything that I can to try to achieve really cost-efficient dispute resolution and it doesn't work, then I'm coming for you. I mean, like, if it's game on and we're gonna have a big fight, I'm gonna do my very best to be the guy dancing around with my hands over my head, when it's all over in a couple of years. And sometimes that's necessary, and there's just no way around it. But the different tools in your toolkit, as a design and construction lawyer, knowing who the other lawyer is and what they're likely to know, and meeting them at a level of, trying to persuade them, as is necessary based upon how much they're likely to understand in the first place, is the first thing, right? It's a different message to a different kind of a lawyer, depending upon if they're, a general litigator, which I don't mean to say in like a negative way, because these general litigators have like a lot of like skills and abilities that they've spent many years investing in developing that I have been, like ruling a jury where, I've spent my time developing like a level of subject matter knowledge in design and construction. So it's not to say that there's anything wrong with those lawyers, but if they don't understand the way that damages are going to be measured, and I can try to explain to them, I have to understand where they're at. So first of all, it's understanding who you're dealing with. But I happen to be a huge fan of mediation, which is a controversial topic, right? If you get together 5 lawyers and you ask them how they feel about mediation, they're going to have 10 opinions. I've been involved in my fair share of poorly conceived mediations that were a big waste of everyone's time. And then I've been involved in mediations that were very wisely conceived and the table was set the right way. And they led to negotiated resolutions that were in everybody's best interest. So, mediation is a form of non-binding dispute resolution, meaning there's no judge or arbitrator that's going to pick a winner, right? It's voluntary in the sense that I show up to the negotiation. A mediation is a facilitated negotiation. The mediator is a third party, usually an experienced construction attorney, who's going to come in and try to broker a deal. But it's voluntary in the sense that whenever it is in my client's best interests to get up and leave the negotiation, we're free to do so, right? If we're wasting our time or if the baby is being split in a way that doesn't work, we can get up and we can leave and we can move on to the next phase of dispute resolution, which is the binding dispute resolution, right? Where a judge is going to pick a winner or a loser, and you don't get to just say, I don't want to be involved in this litigation, right? It's going to happen regardless of whether you want to or not. Arbitration is very similar to litigation in the sense that an arbitrator is going to pick a winner or a loser. But a mediation, it's just a negotiation that's facilitated by a third party that's picked by the disputing parties. And to me, there is no reason in the world why you shouldn't always have a mediation, at the beginning of a dispute. It's a very effective tool of resolving disputes. I push to have mediation clauses in all of my contracts. I'm not always successful because sometimes I run into other lawyers who are representing parties that have more bargaining power relative to my client, and they're going to make the rules and they're going to say, I don't like mediation. They're going to delete it. But early cost-efficient dispute resolution is something that can be achieved through mediation, because if I can get in the room with the decision makers for the other side, which is something that tends to happen in a mediation. I'm not just talking to the lawyers, but I get to maybe have a little interactions with business people. I have the ability to influence them, in ways that I wouldn't otherwise be able to. And so, when I'm dealing with a lawyer, to get back to your question, that doesn't view the world the way that I do, if I'm dealing with a litigator that really doesn't want there to be a negotiated resolution because they want to have a case to litigate for the next year or two, my job is to use whatever tools that I have available to force them to interact with me and my client and their client and the mediator in a way where I get to have my say and to try to positively influence things within the confines of the mediation and the ethics rules that I might not have otherwise had. So, to put it in layman's terms, if I got a lawyer that doesn't want to have a negotiation at the beginning because they think mediation is a big waste of time, I'm going to do everything in my power to force them to go through that process and to have to listen to what I have to say. Because a lot of times we achieve these negotiated resolutions and mediations over the objections, over lawyers on the other side who really don't want the case to settle. But if I'm able to set the table in the right way, a lot of times I'm able to, always ethically and within the rules, sort of like, I don't want to say like have my way with things, but kind of impose my desired process and hopefully to lead to my desired outcome on the negotiation.
So you'd mentioned like you've had mediations that have been great, some that have been not so great. I have to imagine that some of that is the mediator themselves, like that. Obviously that would be the common denominator or the denominator that changes in those. How does counsel pick a great mediator that's going to actually be impactful to get a resolution without just, wasting people's time and then eventually going to court anyways?
That's a great question. Because mediator selection is everything. And if I've got a very important matter, I'll bring the right mediator in from another part of the country in Chicago because there is a definite skill set that I'm looking for. So mediator selection is everything, but it's all. But the reason why it's everything is because the right kind of mediator is somebody who's going to understand that, what business people need to make business decisions is information. And when people say that they don't want to settle, what they really are often saying is they've not yet got their hands on enough information that allows them to make a business decision about whether it's in their interests to cut a deal now or to fight on. And so there's an information exchange that is an important part, of a mediation. And the mediator is able to speak on a confidential basis to both parties, right? I speak to a mediator and I say, hey, I want you to understand this, but don't tell the other side. And that's totally normal, totally ethical. It's happening on the other side too. The other side is sharing confidences with the mediator that the mediator is not sharing with me. These are the rules. But the mediator's ability to speak to both parties on a confidential basis and try to understand what's really going on here is everything. Because what lawyers write about in their position papers isn't really what is driving the dispute. I mean, sometimes people just feel wronged and they need a little catharsis and they need to yell at the other party a little bit at the mediation, and then they're over it and they're ready to do a deal. Or maybe the decision maker is being fed bad information by one of his or her employees that made a mistake, and the employee is concerned that maybe they're going to lose their bonus or their job. And so when the ultimate decision maker is being fed bad information, maybe that is the reason for the impasse. So the mediator comes in, they diagnose the reason for the impasse to the greatest extent possible. They try to figure out how much information needs to be exchanged by the parties in order to put them in a position to make a business decision about whether it makes more sense to fight on in court or arbitration, or whether it makes sense to cut a deal. And then importantly, a good mediator would have a sense to not set a negotiation event before the parties are ready to negotiate. Because, one of the things that I like the least about mediation is that people tend to think about it as an event that happens on Tuesday. A lot of times what a mediator will do right away is they'll say, what's the date for the mediation? And if that's what the mediator is going to do, they're setting themselves up for failure in a lot of cases. Because if you pick a date and everybody shows up, and the business people don't have enough information to make a business decision about what to do, what you wind up having is a positional negotiation where each side stakes out extreme positions, and then both parties leave at the end of the day more angry than they were when they showed up. And that's a process problem. And, and these are not my ideas. I mean, the best mediators in the country, they understand this stuff. These are not my ideas. And, one of the things that I think is most interesting, one of the most interesting developments in mediation in the last couple of years is this thing called guided choice dispute resolution, which is a brainchild of one of my mentors in design and construction law, my former partner at the large law firm Schiff Hart. His name is Paul Lurie. I owe him a great debt of gratitude. He's, the godfather of construction law in Chicago, and he's branded with this moniker, guided choice dispute resolution, the best practices that the best mediators nationally, have been doing for years. He's kind of boiled it down. And I like to go find a mediator that is steeped in these principles, that doesn't call the negotiation session prematurely, that facilitates the exchange of information, that looks past the things the lawyers are writing to figure out what's really going on, what's the cause of the impasse. And then the mediator convenes the negotiating session when people are ready to make a business decision. When that playbook is run, you should almost always have a negotiated resolution. And this is one of the reasons why design and construction disputes are unique. Again, there's lots of reasons why you go to court and you go to trial in other areas of law. If someone's trying to put me in jail and I didn't do it, we're going to trial. We're not going to plea bargain, right? And if there's a patent out there and I think it needs to be busted, if I don't go bust it in court, it's going to be good for 20 years. So we're going to go to trial. And if we have a great difference about what the dollar value of the claim is, we're going to go to trial. And if I have to foreclose a mechanics lien or a mortgage, and I need a judge to order a judicial sale, we'll go to trial. Like, that's fine. But if we're just fighting about money and it's a design and construction case, if you engage smart design and construction lawyers that can fast forward the tape and understand how it's likely to end, and you set up a thoughtful mediation with the right kind of a mediator that doesn't prematurely convene the negotiation session, 99% of the time, people are going to be able to negotiate in a few months exactly the deal that they would negotiate in a couple of years on the courthouse steps the day the trial is about to begin. Because it's just undeniable. I mean, I don't have any empirical data in front of me right now, but I'd say like 99% of all design and construction cases settle, but they settle too late after too much cost and expense because they settle on the courthouse steps the day of trial. And these outcomes are predictable, right? A smart design and construction lawyer dealing with a similar lawyer can size it up, fast forward the tape to the end, get to a negotiated resolution. Now, particular if we've got smart contracts and insurance is working the right way. So there's a big symbiotic relationship between right project delivery method, right insurance, right contracts, right mentality among lawyers, right way to think about dispute resolution. And, there are lawyers out there that lock up criminals that are dangerous, and do a great service to society. I don't do that, right? I help people fight about money to a great extent. So like, if I'm going to make my positive impact on the world, the mission of my law firm is to keep people in the AEC space, to keep design and construction project participants out of this destructive litigation that wastes their time and wastes their money and burns up their hard-earned relationships in the industry. That's what I'm trying to do. That's why my firm exists, is to help people achieve, those peaceful resolutions.
No, that's I love the passion for the purpose. That's what it's about. Once you find it, just attack it until you can't go anymore, right? That's it. Does a mediator have to be an attorney? Because if not, I think I'd be an amazing mediator. I can tell people what they should just be doing.
Not necessarily, although it's useful for the mediator to be a lawyer. There's a lot of former judges, and former judges tend to be in an evaluative mode, right? They're sort of like used to wearing the robe and sitting up on the bench, and they're going to go in the mediation. They're going to say, this is how the case is going to end, so you should settle. But sometimes you need a less evaluative mediator, and you need one that's a little more facilitative, that may understand that the people just need to be brought together in different ways. So there's mediators of every stripe, and sometimes it can be useful to have a non-attorney.
All right. Well, I'll keep that in mind, for when you need a non-attorney lawyer or a non-attorney mediator. You've been great, Jeremy. We've got one more question for you, which I know because you're an avid listener of the show that you know what it is. So Will, take us away.
Yeah. We had asked you had actually told us what the question is, which is great. You were listening. So if you were to go back 20 years, what advice would you give yourself? What would you tell yourself?
So many things. But thinking about the AEC space and design and construction law, and thinking about myself as a young lawyer in 2002, when I was first licensed, I think I would say to myself that don't listen to everything that the mentors that I had at the time 20 years ago were telling me about the way to think about resolving design and construction disputes, because these well-meaning, good people who are very smart and skilled, to whom I owe a great debt of gratitude, had a hangover from a time frame that doesn't really exist anymore. Like, I think that, the people who told me how to be a lawyer in 2002 probably got the same talk from their mentors in 1982, who got the same talk from their mentors in 1962, who got the same talk from their mentors in 1942. And in 1942, in 1962, and 1982, just about every design and construction case went to trial, because there really wasn't the widespread adoption of alternative dispute resolution, mediation, and arbitration as there is now. And so, the lawyers to whom I owe a great debt of gratitude, very wise people who helped me along the way, who told me about the way that I should be thinking about at the outset of litigation, preparing myself for a trial, which is really unlikely to occur. I mean, smart business people are asking themselves, why are we paying design and construction lawyers so much money to prepare for trials which never occur? Like these mentors that I had, who at the outset of litigation that I was starting are telling me about how to be trial ready 3 years from now, they should have been thinking about how to find an off-ramp short of that early cost-efficient dispute resolution, because that's what the clients want. I, as a young lawyer, you can't see the forest from the trees. And so I spent a while, I'm trial ready. Let's go to trial, and then I had the opportunity to work with a lot of business owners in the AEC space and realize what they wanted, in large part because I stand on the shoulders of giants. My partners in the construction law group at Schiff Hardin are the mentors of my lifetime, and I would be nothing if I wasn't able to stand on their shoulders. A lot of these ideas are not mine. These are things that they taught me later. I mean, I had the mentors that taught me what I learned in 2002 when I was starting out, and I was very lucky in 2006 to join Schiff Hardin and work with these people. 10 years into my practice, thanks to the wisdom of, the second round of mentors I had, I think I was able to see the forest from the trees a little bit better. And it's really animated this passion that I have for early cost-efficient dispute resolution. And so if I had to go back 20 years, I would tell, young Jeremy, in 2002, don't listen so much to the lawyers who are giving you advice that is really a hangover from a time that doesn't exist anymore.
Wow, I love the unique perspective, and I love how you just kind of completed the circle. So thank you for that. Thank you for that perspective. Justin, I think it's that time.
Yeah, we're gonna throw all of your LinkedIn and all that stuff in the show notes, so no problem there. But if somebody is listening and they wanted to get a hold of you and your firm, what's the best way for them to do that?
The best way is to reach out through my website, which is www.buildchicagolaw.com. I'm also very active on LinkedIn, and I can't make too many friends in the AEC space, so I'd love to hear from your listeners.
Awesome. Love that. Is there anything else you'd like to tell the people before we say our goodbyes?
I'm just grateful for the opportunity to be on your podcast. I've had an opportunity to listen to a couple of episodes, and I think you guys are doing something really great for the AEC industry, and it's an honor to be here today. So thank you very much.
Appreciate that a whole bunch, Jeremy.
Thank you, Jeremy.
Listeners, I hope you've learned some things. We certainly have in the construction world, AEC world, focused on the legal side of it, which is a very crucial part of scaling your business. So we had fun. Jeremy, he looked like he had fun too, so that we're having a good time. And until next time, adios.
Adios.
Thanks for listening to Building Scale. To help us reach even more people, please share this episode with a friend, a colleague, or on social media.
Remember, the 3 pillars of scaling a business are people, process, and technology.
And our mission is to help the AEC industry protect itself by making technology easy.
So if you think your company's technology pillar could use some improvement, book a call with us to see how we can help maximize your IT and cybersecurity strategy. Just go to buildingscale.net/help.
And until next time,
Keep building scale.